Hi, this is the second part of the program News from Poland, Business and Law, in which we continue to discuss the subject of how a foreigner may be examined as a party in a Polish civil court.
Our program is intended for foreigners acting as board members in Polish companies, foreign investors in Poland, and their foreign advisors.
Let's get started. If the giving of evidence is to take place in a courthouse, i.e. not remotely, on arriving at the courthouse, you will first have to go through a security check, similar to the one in airport departures. After that, you should head for the courtroom stated on the summons. There you need to check the case list. This is an electronic or paper list hung near the entrance to the courtroom. It gives the names of the persons to be heard, together with the times for which they have been summoned. If for some reason the hearing has been moved to another courtroom, this information will be provided on the case list.
The layout of a courtroom is always the following. Under the Polish national emblem, which hangs centrally on a wall, sits the judge. Behind the table and near the judge sits the recording clerk. Opposite the judge's table is a lectern at which, first of all, witnesses testify standing, followed by the parties to the proceedings. To the right of the judge, so to the left when seen by the person giving evidence while standing before the judge, sit the claimant and the claimant's lawyers in court robes. On the left of the judge sit the defendant and the defendant's lawyers. Management board members who are to testify for the company should sit together with their lawyers. On the left side of the room when their company is a claimant, or on the right side of the room if their company is a defendant.
If the hearing is taking place in a courthouse, i.e. not online, third parties may also be present in the courtroom as members of the public. These could be, for example, journalists or former employees of the company that is party to the dispute. The open nature of hearings, allowing the presence of members of the public, is a constitutional principle. With remote hearings, this principle is curtailed. This is because, in practice, the public does not obtain access to a hearing, because usually the court provides a link to the remote session only to the participants of the given court hearing, namely the parties to the dispute, their attorneys, witnesses, and expert witnesses.
Before a hearing begins, you must show the judge your identity card or passport. If you are a foreigner and not fluent in Polish, the court should hear you with the assistance of a sworn interpreter, who will be arranged by the court at the request of the attorneys, claimants or defendants, who have applied to have the parties heard. You are therefore not required to bring your own interpreter to the hearing. Before proceeding with the hearing, the court warns the parties that they are obliged to testify truthfully and that, as appropriate, they may be questioned again after they have given an oath. The court starts the examination by asking a few questions about age, profession, and level of education. When answering questions from a judge, you should address the judge as honored court. In other words, as if addressing an institution or authority. You should never address the judge as sir or madam. The court first examines the witnesses without taking their oaths. If this examination fails to cast sufficient light on the facts, the court may question the party again, but after taking an oath from it. Before taking an oath, the court warns the party about criminal liability for giving false testimony. Therefore, if a party chooses to testify before the court, it should obviously tell the truth.
At this point, we should clarify the issue of criminal liability for giving false testimony. In accordance with the Criminal Code, if in giving testimony intended to serve as evidence in court proceedings, a person testifies falsely or conceals the truth, that person will be subject to a penalty of imprisonment for 6 months to 8 years. Nevertheless, it is a condition for liability that the person taking the testimony, here the judge at the trial, has warned the testifier of criminal liability for false testimony or taken an oath from the testifier. All the same, the court may show extraordinary leniency or even waive the penalty if the false testimony relates to circumstances that cannot affect the resolution of the case or the perpetrator voluntarily corrects the false testimony before the case is resolved.
But let's return to the course of a hearing. When the judge has finished, it is time for the lawyers of the parties to ask questions. First, The board members answer questions from the attorneys of that party to the proceedings that applied for the person to be examined. The next questions are put by lawyers of the other party. When testifying in the courtroom or remotely, online, you must speak off the top of your head. You cannot read your testimony from a prepared document. But beware, while a party is being examined, it may be confronted with documents and witnesses.
During a hearing, video and audio recordings are made. A camera is positioned above the judges' heads. Irrespective of this, the judge usually dictates to the court clerk successively what the latter should enter into the written record documenting the testimony. The person who is giving the testimony may correct this dictated text as it arises if the person finds any errors. Also, at the end of the examination, the person may ask the court to read the testimonies. If the testifier notices any errors, that person may request the court for written record to be supplemented or corrected. Important note: if the examination is being held with the assistance of an interpreter, one should speak clearly into the microphone and provide short breaks every 2-3 sentences so that the interpreter may faithfully convey the testimony to the court.
If the hearing is taking place in the courthouse, therefore not remotely or online, the question then arises of the reimbursement of travel and possible accommodation expenses. The party's lawyers should apply to the court for an award of these costs in the final judgment. As a general rule, these costs must be paid by the party that loses the trial. And that's all we have on this subject.
We hope that you find our program useful. See you again soon.